Harry on tenterhooks as judge orders DHS must hand over his immigration papers ready to be in public. A judge has ordered the Department of Homeland Security to hand over sensitive material about Prince Harry's immigration papers for him to review while he decides whether to make them public. Judge Carl Nichols told DHS that its arguments so far were insufficiently detailed for him to make a decision. He asked the agency, which oversees immigration, to give him declarations explaining the particular harm that would arise from the disclosure of the Duke of Sussex's visa application. In an order filed to the court in Washington, Judge Nichols stated that the Freedom of Information law authorized him to review declarations and/or contested records in camera. Doing so would help him to determine whether any exemptions preventing the documents from being made public apply. Such a review is appropriate when agency affidavits are insufficiently detailed to permit meaningful review of exemption claims, when the number of withheld documents is relatively small, and when the dispute turns on the contents of the withheld documents and not the parties' interpretations of those documents, the order said. Judge Nichols said, having reviewed the parties' written submissions and heard oral arguments on the motions, the court concludes that in-camera review is necessary to determine whether the records in dispute come within the scope of the claimed exemptions. Judge Nichols gave DHS until March the 21st to submit declarations that detail the records it's withholding and the particular harm that would arise from public disclosure of them, his order said. The review will be conducted in camera, meaning it will be done by the judge in private. The development came after a hearing at the court in Washington last month in which Judge Nichols heard from DHS and the Heritage Foundation, which is seeking to release the material. The Heritage Foundation, a conservative think tank based in Washington, D.C., filed the Freedom of Information Act against the Department of Homeland Security, after Harry admitted to previously using hard substances which they argue should have disqualified him from entry into the US. If the Duke didn't tell the truth in his entry forms, then he could be removed from the US or barred by a border agent. In its legal filing, DHS said that the records at issue are particularly sensitive because they'd reveal Harry's immigration status in the United States. The DHS has claimed that Harry still has a right to privacy even though he's a celebrity. In one of the DHS's earlier interactions with the Heritage Foundation, they told Niall Gardner that they were unable to locate Harry's file. The Heritage Foundation knows DHS is trying to hide the weenie on this, which simply makes them more resolved to view the contents. The judge will not and should not accept the dog ate Harry's file excuse. Harry's still on record as saying that he doesn't like England and that the US is his home now. We know if he ever returned to England, it would be entirely driven by whatever financial benefit he thought he could get from it. He didn't include Scotland, Wales or Northern Ireland in his declaration of dislike, so maybe he'll try to fudge his way out of accusations of hypocrisy by settling in one of those countries. I see no evidence he's any more popular there, but it would enable him to say, I didn't say I disliked the UK, just England. I've always thought that there's the possibility that Harry entered the US in 2020 under his then existing IPP status and has never applied for a visa at all. Is this possible?